Be ready. 5 seconds.
The present appeal arises out of the judgment of a division bench of the High Court of Kerala. Stop. The death sentence reference and the criminal appeal arose out of the judgment of the Court of the Additional Sessions Judge bracket ad hoc bracket close stop. The trial court found the appellant bracket the sole accused bracket close guilty for having committed murder after committing house trespass stop. After committing the above said act, comma, the accused attempted to commit suicide for which he was also found guilty. Stop. The trial court sentenced the accused to death for the offence punishable under section 302 IPC. Stop. For the offence under section 449 IPC, comma, the accused was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 1000 and, comma, in default, comma, to undergo simple imprisonment for 6 months. Stop. The accused was also sentenced to undergo simple imprisonment for 2 months and to pay a fine of rupees 500 for the offence under section 309 IPC, comma, and in default of the payment of fine to undergo simple imprisonment for 1 month. Stop. When the matter went for confirmation before the High Court, comma, the High Court, while confirming the conviction, comma, modified the sentence. Stop. The sentence of death was modified and reduced to imprisonment for life with a further direction that the accused shall not be released from prison for a period of 30 years, including the period already undergone with set off under section 428 CRPC alone. Stop. Aggrieved, comma, the appellant is before us in the present appeal by way of special leave. Stop para. We have heard learned counsel for the appellant, comma, who advanced elaborate arguments, comma, covering the entire spectrum by making available a chart setting out the summary of the deposition of the prosecution witnesses, comma, the relevant exhibits marked and the argument of the defense in separate columns. Stop. He mainly contended that the case made out by the prosecution falls short of the proof needed in a case which is based entirely on circumstantial evidence. Stop. Learned counsel contended that with the available evidence it would be unsafe to sustain the conviction and pleaded for outright acquittal. Stop. The specific contentions of the learned counsel challenging certain individual circumstances have been dealt with herein below while tabulating the circumstances. Stop. Alternatively, comma, learned counsel pleaded that the sentence of 30 years without remission is excessive and prayed that the sentence may be appropriately tailored to meet the ends of justice. Stop. Learned senior counsel, comma, for the state vehemently rebutted the arguments of the counsel for the appellant and contended that the trial court and the High Court have correctly arrived at the conclusion of guilt. Stop. Learned senior counsel contended that the case actually warranted death penalty, but the High Court has modified it to a sentence of imprisonment for 30 years without remission for the offence under section 302. Stop. According to the learned senior counsel, comma, the sentence did not deserve any further modification. Stop para. We have carefully considered the submissions of the learned counsel for the respective parties and have perused the material on record, comma, including the relevant original trial court records. Stop. The circumstances that unerringly point to the guilt of the appellant as it emerges from the deposition of the witnesses and the duly proved exhibits can be summarized. Stop. We uphold the judgment of the High Court insofar as the conviction of the appellant under sections 302, 449 and 309 IPC is concerned. Stop.